Good evening, ladies and gentlemen. My name is Nigel Duncan, and I am here at City Law School, and I would like to welcome you to the school for the 2015 Lord Upjohn Lecture. Before I hand over to Chris to introduce our lecturer, I have two announcements to make. The first is that we're not anticipating a fire alarm. So should the fire alarms go, you can probably guess it's up the stairs, out the front entrance, and away from the building, please. Secondly, just to let you know that this lecture is being recorded. So if you wish, and we hope you will wish to, I'm not sure whether Becky does, but we hope you will wish to ask questions and make comments, those will be recorded as well. Incidentally, when we get to that point, we've got a couple of roving mics to make sure that we can hear you. Okay? Now I'd like to hand over to Professor Chris Ashford, who is Chair of the Association of Law Teachers, to introduce our speaker.
Thanks, Nigel. Good evening, everyone. It's lovely to see so many people here tonight, and so some fresh faces as well, which is quite nice, and some people who haven't been to Upjohn's for recent years. You've got a whole range of literature in front of you, which I know you're going to be so gripped by Becky's talk, you're not going to read until the end. But you'll see a series of handouts there that show you all the past Upjohn lectures and some of our fabulous speakers that we've had over the years. You'll also see a little postcard that you can all take away with you and treasure, pinned on your fridges, that is highlighting next year's annual conference, 2016, and we're up in the magnificent city of Newcastle. And you can see there where we'll be having some of our social events at the Baltic and at the Sage in Gateshead. It's going to be at Northumbria Law School, and the call for papers is live. On the back of the card you can see the web link, so please do get putting your proposals in. You'll also see in your packs that we have next year's lecture already organised with Dame Linda Dobbs. I hope you'll be circling your diaries for November, and we'll be giving you the exact date a little bit later on next year. Also, there's a shameless plug for a book which is rather expensive, as some of you will have noticed. One for your libraries, I think, on Perspectives on Legal Education. And this is a collection edited by myself, Nigel, and Jess, who are all here. So you'll have to wait a bit longer for signed copies, I'm afraid. And this pulls together a whole series of past Upjohn lectures, as well as some modern reflections on issues in legal education, including our speaker tonight. So that's surely reason enough to put that on your Christmas wish list. And sceptical faces. This is surprising me. I don't know why. And if any of you are not members of the ALT, which I find hard to believe, but if any of you are not, which is have a word with yourselves, because that's disgraceful, then there are application forms here as well, so no excuses whatsoever to fill in and join us and be part of this fantastic organisation. For those of you who tweet, you'll see that we've got a hashtag for the evening. Those of you who don't tweet, I'm not talking about drugs. This is the Upjohn 15, so Upjohn 15 is the hashtag for the evening, so if you are on your phones, we'll assume you're tweeting and not giving up and messaging home for help. If you want to get retweets, then please do use the ALT Law, and then Zoe, who will be shamelessly photographing and tweeting like mad throughout this session, our paparazzi in the crowd, will be retweeting as well. So if you want to boost your followers, sounds all messianic. Over 1,000. So please do tweet the ALT and share fantastic news with you. It brings me to our speaker tonight. And our speaker is known to many of you, and you've got a biography in front of you which doesn't in any way do this person credit. She's a phenomenal character, a star, quite literally this evening, a bright star, blindingly so, some might say. A star of the legal education movement, someone who has made a major impact when it comes to thinking about quality in legal education and thinking about benchmarking. And more recently, Becky's work has really informed what the Bar Standards Board in particular have been doing. As chair of the QAA, it's fair to say she had a bit of a say on that document, which is going to influence legal education across this country. She is an amazing character, an amazing part of the legal education community. and she's going to be talking to us tonight about tripping over thresholds, capturing the legal education process and outcomes. Over to you, my darling.
Thank you. I've already changed my mind on where I want to stand. Some people. I am delighted, thrilled, and very honoured to have been invited to deliver the annual Lord Upjohn Lecture. I've been attending these lectures for a number of years, and I helped arrange the last two. And I think you all know the esteem in which I hold the Association of Law Teachers, and I praise unreservedly and unconditionally all the committee does to contribute to and steer the direction of legal education across the UK and internationally. Thank you so much for this opportunity to share some of my thoughts about legal education with you. So now, if you're able to, please would you stand up? She was expecting that. You all ready? Please remain standing if you think like a lawyer. If not, please take a seat. Some were thinking and hovering. Remain standing. For those of you still standing, and please understand for the purposes of a lecture this is rhetorical, which one? I don't have time to explore your thinking now. And I know this phrase is loved and loathed in equal measure by many, many colleagues. But when you think like a lawyer, which lawyer is it? Is it a solicitor? Is it a barrister? Is it a judge? If it's a judge, is it Lord Denning? Is it Lord Sumption? Lady Hare? Is it an academic? Is it your law teacher? Do you even have a role model? Or when you think like a lawyer, are you thinking in a lawyerly way and therefore that is a lawyer? Please have a seat. Thank you for playing along. This lecture tries to explore legal education in part by investigating the phrase thinking like a lawyer, which until I finished this lecture, in my preparation, I loathed. I'm going to explore it in the context of threshold concepts. So I'm going to be exploring ontological questions. That's the best slide I could find on ontology. And that is causing us to consider our view of reality and epistemological issues, which will involve how we acquire knowledge and what knowledge is, albeit in the context of legal knowledge, skills, behaviours, attributes. I address this point, however, to those who remained sat down. I apologise, I don't at this stage have time to ask you why you sat, nor why some of you hovered and then sat. But it may be because it is your ontological view that you do not think you think like a lawyer. Or it may be your epistemological view that it's not something that can be known or learnt. And both of these views are as worthy of investigation as thinking like a lawyer for those of you who remain standing. What I'm going to talk about is threshold concepts. Forgive me if you already know this, those of you who perhaps don't. A threshold concept is a learning experience. It is a thought process or processes which resemble passing through a portal from which a new perspective opens up, allowing things not formally seen to come into view. It is a transformation in our understanding. It reformulates our frame of meaning in our discipline. But the journey across that portal, as beautiful as that looks, isn't necessarily easy, and it isn't always comfortable. Because threshold concepts are transformative, they're often irreversible, but they're troublesome. And some have described them less as a portal and more as a hurdle, and sometimes a barrier, and sometimes a brick wall. But crossing the threshold changes the way you think and act. They came from here. The authors, Jan Mayer, Ray Land, and Caroline Bailey, who came on later, were trying to understand why and when students get stuck. And their investigation became so much more. They're looking at transformation and portals. And threshold concepts are exciting because they do facilitate a transformation in the learner. I can vouch for this. I felt that I've gone through a threshold concept to understand, educationally speaking, threshold concepts. There is an epistemological change because they capture the cognitive and affective parts of our brain. You know the difference between what you know and how you feel about it. Frustration sometimes. And they're, ontologically speaking, they're transformative as well. Because they can change how we see ourselves, our identity, our reality. And they can give us that epiphany, that light bulb moment. They can provide us with a new world view. Don't take my word for it.
Hi Becky, this is John Flood. I'm trying to figure out what my light bulb moment was, and I think it came when I was travelling on a train across the Sahara Desert some years ago between the bottom of Egypt and Khartoum in Sudan. And the train got increasingly full, and the fuller it got, people started sitting on the roof. And it was illegal to travel on the roof, but the way you did it was to tie yourself by a rope to the pipe in the middle of the roof and just sit there and hope you don't fall off. The ticket inspector came down and he punched all the tickets anyway, so people seemed to think it was all right. Until at one point a guy fell off, and when he did, the train had to stop, and the guards came from the van at the end of the train and they arrested him. I asked somebody why, and they said, oh, well, because he was illegally travelling on the roof. And while this was going on, everybody was screaming at him and shouting and yelling for holding up the train and having fallen off the roof, and he was taken away. And I sat there thinking, well, what on earth is going on here? How does this make sense? But I suppose what it made me realise is just how subtle, open, nuanced the interpretation of law is. That it's not just a simple binary operation, black, white, yes, no, right, wrong, legal or illegal. It has many flavours, interpretations, many facets which are in a way embodied in us. So I think that's what it did it for me.
With thanks to John Flood so much for that. So John's moment was the realization that law is nuanced, subtle, not binary. And this is dreadfully troublesome for those of us employed to teach students, because it means the law and learning the law, not necessarily what students expect. The multifaceted nature of law means the novice student seeks the right answer and can't always find a simple yes or no, right or wrong. And pretty much universally across the literature in threshold concepts, across disciplines, across jurisdictions, across levels, handling uncertainty is one of the most commonly identified threshold concepts, and the literature explains just how troublesome that is to learn. And they're troublesome because, although they often build on core concepts that learners can know and understand, learners don't connect those core concepts until they cross the threshold. That's the nature of the threshold concept, because it's described as being integration of those basic concepts, and passing the threshold brings them together. It means they often need to know quite a lot of law before they can see the bigger picture, and that's why that is another reason why it's so troublesome. It's also described as liminal, A liminal relates to transitions. But in anthropology, liminality captures the quality of ambiguity and disorientation that occurs in the middle stages of a ritual or rite of passage. And that's why the between catching on. So student learners can be preliminal, liminal is not a comfortable place to be, and postliminal. But John Flood's post-liminal epiphany wasn't comfortable. It's not like you get there and go, woohoo, I'm safe. Because his rite of passage was to recognise how nuanced and subtle and complex the interpretation of law was and is. And that isn't a comfortable thought. But I wonder whether we can say that's what a lawyer does. It's thinking like a lawyer, being prepared to be unsure or in doubt. And if we talk about uncertainty and complexity in law, here is Richard Moorhead talking about when he realised the bigger picture.
What was my legal learning epiphany? Well, it was in a clinical legal education class at Warwick University, legal practice, and they had us dealing with real clients, and I was advising a client on a small claims hearing. We were due to go and represent them a week or two later, and we were going through their case, and I think it was at that point that I really started to grapple with the uncertainty of law, how uncertain some of the basic concepts were, what it might mean really to deal with something like reasonableness, say. And it was at that point that I think that I understood some of the power and responsibility that was engaged by being a lawyer, and that was for me the moment that my legal education really, if you like, lit up.
That power and responsibility in the context of uncertainty, and it's that uncertainty that I'm going to explore now. Many authors have identified uncertainty across disciplines as a threshold concept in law. And in law, the concept of the contingent nature of law. Aidan Ricketts, who writes in this area, suggests that thinking like a lawyer is a threshold concept itself. Not just because it is uncertain, the law is uncertain, but he suggests it's because the law involves a counterintuitive form of discourse. And he illustrates this by way of several examples, one of which is that a corporation is, in law, a person. And he says that's counterintuitive. I would say this is part of the nature of law, but I'm exploring thinking like a lawyer, and I'm not sure being able to grasp the counterintuitive nature of law is necessarily part of being a lawyer. I'm open-minded to it. The reason I say that, though, is there are elements of cognitive dissonance throughout the world, the commercial and professional world. This isn't unique to law or lawyers. Nick James, Australian writing in this area, agrees. Thinking like a lawyer is a threshold concept. He warns about adopting a narrow definition of the phrase, limiting it to, for example, engaging in formal legal reasoning, recognizing legal issues, locating relevant legal rules, applying the rules of law to the facts of the problem, and reaching an evidenced and rational conclusion. He wishes it to be expanded, I think because he teaches ethics, to include an appreciation of ethical practice and social justice, and identifying and working with policies underlying legal rules, and then he goes further, taking advantage of the fundamental indeterminacy of the law. And it's this fundamental indeterminacy that we see as a theme through some of the writing. Judith Wegner, who some of you will know is a co-author on the Carnegie report in the United States, looking at stages of apprenticeship in becoming a lawyer, spent a long time looking at the phrase, thinking like a lawyer. And she thinks the phrase is important. But she thinks that the phrase may be part of the problem. She calls it a wicked problem. and a naming problem, which is why Rumpelstiltskin appears on the slide. Because the phrase fails to acknowledge the complexities of the issues involved in law and legal learning. She says there are multiple dimensions that are interrelated, easy solutions that are not readily available, and resolution or attaining competence is rarely a linear process, but rather one that involves a good deal of trial and error in working with solutions, not just the problem itself. She asserts the phrase thinking like a lawyer deserves to be unpacked, deconstructed. And I'm doing her a disservice here by summarising that she thinks thinking like a lawyer, in fact, involves three elements. The process of reasoning, which is a form of reasoning situated in the legal context. The nature of law, and the changing nature of society within that, and the role of lawyers with their power, responsibility, and roles. She does, of course, include the uncertainty of law within her examination of thinking like a lawyer, and she says that legal educators are well aware that the challenge of grappling with uncertainty at times paralyses law students. That's part of the liminality. But she says that dealing with uncertainty is not unique to law, and she must be right. My reading suggests that professionals in all disciplines are required to deal with uncertainty. And it may be the hallmark of the expert that they are able confidently and competently to identify, deal with, and manage uncertainty in their field. In her research, it was suggested to Wegner that critical thinking was the threshold concept in law. And she asserts it may be one, but it's not the only one, because whatever we may think of ourselves, we're not the only people who think critically. And perhaps this is or should be obvious. Given that every year I taught on the jurisprudence module in the final year at Nottingham Trent University, and I was started with, how you doing? You enjoying your law degree? Yeah. You're in your third year of your law degree now. Well done. So, let's start with something easy, shall we? What's law? And you'd feel by your third year, you'd know. And the confusion, the horror, just a brief discussion for the first few minutes allowed students to realise there is no universally agreed definition of law. And if we can't find a universally agreed definition of law, how are we going to find a universally agreed definition of what a lawyer does or thinks? Wegner, leaning, I think, quite strongly on Dewey, says that it is the uncertainty of and in the nature of law that leads to the best thinking about law. There's further research done by someone called, I think his name is pronounced Huxley-Binns, in Australia. And he investigated thinking like a lawyer with law students. And they went through several different ideas, but settled on legal reasoning as the threshold concept. So when I first saw legal reasoning, I thought of IRAC. It's how I was taught law, or how to structure an answer. And it's not easy, but it's quite simple. You identify the issue, and there's some complex processes involved in identifying the issue. Researching the rules, there's complexity therein, applying the rules, and reaching a conclusion. But I think that skips over the processes if we're to deconstruct thinking like a lawyer. Because learning about law and using authorities well, learning about the authoritative nature of those authorities, and handling the uncertainty and ambiguity in law isn't captured in IRAC. And Huxley-Binns' research didn't adopt the IRAC method. They thought that legal reasoning provides students with a sense of self-identity as a lawyer. They pass through the portal of knowing what it means to be a lawyer. Once inducted into legal reasoning, a student is able to look at the other side and accept there is no right answer. They know they have to think deeply about meaning and argument and be persuasive, problematize and question issues, test the facts and the boundaries and the limits of the issues. And picking up on this idea of the identity of the lawyer and the student reading law, inculcate students into the integrated nature of the culture of legal argument. Taking responsibility for your position contradicts the possibility of simply making an assertion without backing it up. And that's why I've never lost an argument, because I will invent the authority if it doesn't exist and make sure I'm arguing with someone who doesn't know, or I'll move the goalposts. Thinking like a lawyer or legal reasoning, the threshold concept forces students to reconsider or possibly change their preconceptions of what law is. That's from a student. Saying it changed my preconception of what the law is and what it can achieve. I summarised some other research by Melissa Weresh. She echoes much of the research done elsewhere, but she argues the threshold concept in law is law's malleability. She defines that as an understanding of the latitude or flexibility a lawyer has in articulating the legal principles. I don't know what you think, but I think when a person defines law's malleability by reference to the lawyer, it speaks to me of legal realism. And I think I could have quoted Oliver Wendell Holmes here, or Jerome Frank, or Carl Llewellyn at this stage. So let's look in more detail at legal learning. This brings me not before time to my role on the law subject benchmark panel in 2014 to 15. I was invited to chair the working group looking at the 2014 iteration of the law subject benchmark, which had first been designed in 1999, published in 2000, again in 2007. And I said yes, and then had to find out what a benchmark statement was. And each of the benchmark statements across higher education across the UK defines what can be expected of a graduate in that subject in terms of what they might know, do, and understand at the end of their studies. So what we often said in the panel is I want you to think of the student walking across on graduation day, the student graduating with law, LLB, BA law. What makes them different from all other graduates on the day? Because law is not general studies. Before I look into the answers that we came up with, I want you to know I do know the controversy surrounding subject benchmark statements. When they were first mooted in the late 1990s, this idea there'd be a syllabus. And also, there continues to be very strong arguments against outcome-based education. I'm not calling for the subject benchmark statements all to be redesigned in terms of the journey and threshold concepts. That's not their role. But I do think that what we did on the working group was trying to look at what makes a law graduate different from the other graduates, and we borrowed a lot of the ideas from threshold concepts in formulating that. I assembled, I think it was the biggest group for the subject benchmark statement in law. And it's academics, legal regulators and practitioners. And I would like to take this opportunity formally to thank for their help, their guidance, their wisdom, their challenges, the disagreements along the way. When we first met, I asked the group, the first task, developing conversations that we've been having as part of this subject association meetings after the legal education training review, the graduateness of law. We wanted to capture the essence of law as an undergraduate discipline and articulate what makes the law graduate different from the others. And I had a bit of a problem because it's phrased in terms of outcomes. And everything we were thinking was describing the journey to graduateness, which I think is now used so broadly across the sector we can say it is a real word. And I wondered whether I could do this, whether I could chair, because all of my previous research had been about the legal learning journey, the process, certainly one that for me has never stopped. And now I was being asked to focus on the target, the goal, the outcome, that final assessment that shows competence. And could I still focus on crossing the portal or the journey? And did it have to be either or? Well, we think we did merge threshold concepts with threshold outcomes. And we started by borrowing from the history subject benchmark statement. Instead of listing knowledge and skills, we described the subject benchmark outcomes as the skills and qualities of mind, as a subtle distinction to describe the qualities of thinking, not like a lawyer, but as an undergraduate, crossing over that stage and at the other end being a graduate of law. So we included intellectual independence, including asking and answering cogent questions about law and legal systems. And it's the process of asking and answering the questions about about the law, that distinguishes the law student, the law graduate. And we added, and this was the first time it had appeared, and in a law subject benchmark, but doesn't appear across many other subject benchmark statements, even in the non-law disciplines, the ability to recognise ambiguity and deal with uncertainty in law. But you don't see references to ambiguity and uncertainty across many of the subject benchmark statements, notwithstanding disciplinary research that the threshold concept in that area is dealing with uncertainty. It is, in the history one, described as an inherent problem in the historical record, that there's ambiguous, conflicting, or incomplete data, but it doesn't appear very broadly. And what I think we did there is we took a threshold concept in law and stated it as an outcome for undergraduate legal education. For me, that was probably the most significant thing that we did on that panel. And certainly in the responses to it, nobody raised an issue about its existence. But what I had done is I'd used the word tolerate in the first draft, the ability to tolerate ambiguity and uncertainty. I was thinking of tolerating in the Isaiah Berlin way, that this is an active thing you have to do if you want to tolerate something and you don't necessarily agree with it. And I'm grateful to people who responded to it. Recognising and dealing with is rather better. Further, we added, well, this was already there. The 2007-2000 version had principles and the values of law. We added and justice, principles and values of law and justice, and of ethics. That was one of the leading recommendations of the Legal Education Training Review, and ethics is in the law subject benchmark, much to 100% of respondents to the law subject benchmark consultation agreement. We also had awareness, no, we didn't, knowledge and understanding of the theories, concepts, values, principles, and rules of public and private laws in an institutional, social, national, and global context, and the ability to produce a synthesis of the doctrinal and policy issues, presenting a reasoned choice between the alternative solutions, including critical judgments, the merits of a case. And it's this latter point that I wish to illustrate with our next guest speaker, who is in the audience today. This idea of asking questions and getting a synthesis, a pulling together of things that were disparate and untidy and troublesome and difficult. And then the final realization that it didn't have to be that hard. Oh, please.
It sounds simplistic, but things all came together for me through a legal skills class, probably why I'm so obsessed with skills teaching now. Gaining a structure with which to tackle a problem, identifying questions I should be asking myself, and understanding what the market actually wants changed the way I approach the subject altogether. The fog I had felt initially when faced with a problem started to dissipate more quickly. I was more attuned to what I'd actually had to take away from the reading of a chapter in a textbook or a journal article. My note-taking strategy changed. I crept away from my safety blanket of copying everything down and began to become more critical because I knew the purpose for the notes. Everything became that much easier to understand. It's a simple thing, not a glamorous recollection of something earth-shattering that made me want to become a lawyer in a traditional sense, but it did change my life, and it's strange to look back now and see how fundamental that was to me then and where it has unexpectedly led me now, being a lecturer, teaching modules, including legal method, to law students.
Thank you. And what Emily, her post-liminal reflection, perhaps what she described as simple, might be simple, but it wasn't easy. And nor are, I'd suggest, the outcomes in the law subject benchmark statement, because learning the law isn't. Now, personally, I have never seen threshold concepts grasped better, portals crossed, transformations achieved, thinking like a lawyer better than in a moot. Sometimes during the moot, when the students finally realise the connections they're making on their hind legs, when they suggest, for example, a judge should distinguish what might otherwise be seen as a binding authority. And those of you who judge moots know that one of the most difficult questions, the first difficult question is, what is the ratio decidendi of that case? And second, am I bound by that authority? And when the student realises you're not, and makes those connections, the epiphany is before your eyes. Of course, not all students have that epiphany. And they don't all have it during moots. And of course, some students mimic. And this is in the threshold literature. A student who goes through the steps that they think, mimicking what they think lawyers do and how lawyers behave, and still passing. I can't stop that. This is something that some people survive their whole lives by doing, is mimicking the grown-up that they think they should be. Mimicking, in my position, the professor that you think you should be. You can't prevent mimicry. Outcomes-based education can't prevent mimicry. So I just want to put that out there. This isn't a solution to that. But what I am asking us to do is be aware of liminality in law. Be aware of the threshold concepts. And be aware of where students sometimes need a nudge or sometimes need a hand to cross the liminal space so we can be there to help. Bearing in mind, not all of us learnt at the same pace, and not all of our students do. And not all epiphanies are obvious or instantaneous.
Hello, I'm Chris Ashford, and I've been struggling with this question of the light bulb moment. And I guess some people do have that moment when a switch is flicked and when there's the flash above their heads and that kind of eureka moment. I guess if I was a light switch, I'd be a dimmer switch. Rather than one single moment, it's been, you could say I've been slowly getting turned on, but that sounds a bit wrong. But it's been a series of moments rather than one moment.
Sorry, that's my bad editing. Chris continues.
And so I kind of went through these stages of law being something artificial, law then evolving into a bit of a game, something to play, something that was fun, seeing law then as something that can impact on people's lives. And then it became really personal. It became something that was impacting on my life, that was shaping my life, and also something that could be shaped, something that isn't fixed, something that's contestable, something that we see all the time being contested, but we maybe don't think of it like that. And that approach to law, that approach of law, thinking about it in context, thinking about what it means for real people, that's still something that drives me today. It's something that informs my teaching, it's something that informs my research. But I don't think I've yet had that complete light bulb moment. I think I'm still having those moments. I don't think it ever stops. And I think that's the power of law. I guess if there is a kind of way of thinking about law, it's recognising that it's a journey that just keeps going, that you're continuing to argue about law, you're continuing to debate law. I think that's what makes it so vibrant and so exciting.
A journey in and about law that's vibrant and exciting. So is thinking like a lawyer a journey? Or is it something that can be achieved? Or is it something transformational or irreversible? So is it about thinking like a lawyer? Let me explain why it isn't. Because on its own, there ain't no such thing. Or rather, we should avoid using this phrase, please, unless we are prepared to unpack it and dissect it and consider the ingredients and the knowledge and the behaviours and the skills associated with it. Because there is no doubt there are ways of developing thoughts and behaviours about law. So what was my light bulb moment? I didn't have one. I was in a liminal state for a very long time. I call it my undergraduate experience. I'll give you an example. My final year, looking at the roles and responsibilities of directors of companies. And it only made sense when I'd finished the whole of the company law syllabus. And I could see the bigger picture. But it was never an epiphany. But I kept going, which is testament to the quality of the teacher I had, who could see the pain I was in every lecture. No, it's gone. Her encouragement that it would make sense eventually. And she was right. Some of it made sense eventually. I understood minority shareholders' things. Can't tell you them now. But I understood the importance of a minority shareholder before the exam. She told me it would become coherent. And for that short period of time it did. But it was no light bulb. I didn't have one as an undergraduate. In fact, it was much later. This is me and my best friend at Take That. She's Sarah. I've known her since I was 6. She's a midwife. She's awesome in every way. Not just because she's a midwife, but she's awesome for that as well. And she works in a hospital, as midwives generally do. And she received a letter from her employer changing her contractual terms, changing her working hours and her shift pattern. She read the letter. She handed it over to her husband, Bruce, who read the letter, put it on the kitchen table and said no more about it until I popped round for a cup of tea. And they said, Bex, there's a letter on the table. Would you do that thing you do? And those were the words they used. Do that thing you do. I didn't reflect on that till much, much later. So I read the letter and I said, it's a unilateral change in your contractual terms, darling. So what's that mean? I said, they're changing your contract. I can't do that. They can't. That's right. What can I do? Accept it or leave? Shit, yes. We went through all the different options that she had. But ultimately, she changed her shift pattern. And then on the drive home, I thought, what's that? Do that thing you do. What did she mean? I had to absorb quite a lot of complex data in an area about which I knew very little, NHS working patterns. I had to ask her a series of questions. What do you do now? What change would it mean for you? So consider various approaches to her problem, seeking furthers and betters along the way. Consider the different options and advise her on those options in a way she understood. And then I realised she paid me a tremendous compliment. And you might not think it's needed, but it built my confidence. I'm not professionally legally qualified. And after a little bit, I realised, yay me, I just did a thing in law. And I carried that into the classroom. I've told my students this story, doing things with law. And reflecting on my own preparation for this lecture, it made me realise the importance of understanding why we each need to think of our own learning journey and our students, their skills, their attitudes, and remembering that learning the law is personal. And that's why threshold concept should inform our teaching, but not dictate it. And of course, we need to teach each student and facilitate each student's journey so they can find their way of thinking about law, and not worry too much if we didn't have that epiphany when we cross the threshold. The next slide is a confession from a simply excellent teacher and a real game changer in legal education and research in legal education, who feels never had that moment of epiphany, I'm afraid, finding much of my law degree alien, bemusing and worrying, spending most of the 3 years feeling like a bit of a fraud. I didn't have aspirations to be a proper lawyer, unlike most of my peers, and was constantly surprised that I was managing to get decent marks without ever feeling I had, in your words, got it. It probably explains why I've devoted so much of my life to supporting better legal education. I suppose my epiphany was that it doesn't have to be like this, and what's more, I'm going to try and prove it. And the way I was taught 30 years ago was still pretty traditional. We all sat at the feet of our professors and waited to be enlightened. Rarely happened. And that made me wonder whether the phrase thinking like a lawyer can possibly be rather damaging and undermine our identity. So, why did I call this lecture Tripping Over Thresholds? Well, primarily because I wanted to include thresholds, and a good friend of mine suggested I could call it Tripping Over Those Thresholds, which I thought sounded lovely. But also, after I decided on the title, I realised that it is a journey where you can trip up. That even if it is a long journey with steps up or steps down, it's not uniform and it isn't a simple, clear trajectory. This lecture's given me the opportunity to consider whether thinking like a lawyer is a threshold concept or whether it has constituent parts. I looked at whether or not the threshold concepts we looked at could inform threshold outcomes in developing the law subject benchmark statement, which we did try to do. And it made me remember that learning the law is hard. Do you remember how hard it was? If you do teach law, I wonder what you think about recasting your identity as someone who helps a learner over a threshold. Might not. Does it help you remember or appreciate the liminal nature of learning an uncertain discipline? The threshold outcome statement of the law subject benchmark is set at level 6, bare pass. That's the job subject benchmark statements. And I am aware that a lot of students will pass that without having crossed a threshold concept. I did. But let me describe for you, just to finish off, the legal learner in my mind. And I think we all have pictures of those students who did, and you may be thinking of yourself. They don't simply recognise ambiguity and deal with uncertainty in law, for example, from the threshold statement, no. They seek out ambiguity. They look for the uncertainty. They pursue the argument that is yet to be had. They dissect the source of the information and assess its provenance. They perceive the letter of the law and the spirit of the law, and they recognize if they conflict. They seek a precedent to bind or distinguish. They adopt a convention when it serves their purpose, notwithstanding it may be a counterintuitive convention, with a nod to Ricketts. But they're willing to use it as the exception that proves the rule, if not. They appreciate the difference, if there is one, between what the law is and what it ought to be. And that's why ultimately I've come round to not hating, not loathing the phrase thinking like a lawyer, because that could be everything captured in that phrase. Thank you very much. I can't get on that.
Yes. Thank you, Becky. We've got an opportunity for some questions now, and Nigel and myself will run around the room.
Or epiphany sharing without questions would be fine.
Do I need to switch it on,
Hello? Hello? Yeah, just press the back button. And then it should work.
We've got...
This one works. This one works.
There is an opportunity for some questions. So, do you have any questions about or
Should we drink?
Perhaps if you could say who you are.
Yeah, John Hodgson, Nottingham Law School. I suppose the epiphany came when I met up with one of my former university colleagues about 2 or 3 years in after we'd left and gone our separate ways. I had just secured custody of a small child for the father against the opposition of the mother in the 1970s, when this was quite difficult. He had just secured judgment for his client for $20 million in a dispute over something or other. And each of us was chuffed to naffy breaks with what we had done. Each of us recognized that we could not do what the other was doing because it would have totally freaked us out. And I think you can see thinking like a lawyer is not thinking like a lawyer, but thinking like one of very many lawyers. And I think in my father's house there are many mansions. In the Inns of Court there are many places to go. And so what you get out of law is what you put into it coupled with your own personality traits. So I don't think I had an epiphany in the Road to Damascus light bulb turning on sense, but I did get to grips with why I was comfortable with being a lawyer, because I could see that I was doing useful things for people. And it was the law that I'd learned which enabled me to do that. It was knowing the rules, being able to apply those rules and persuade a court that it should do what it would not normally have done. And that is, I think, what thinking like a lawyer is. It's being able to use what you've got in your way and not necessarily in the way other people do it.
Thank you. But I see people do that on The Apprentice, in a business context. And I know the quality of law, and I know the quality of your teaching, your understanding of law is encyclopedic. And I've got no question that you think like a lawyer. But I think you've done yourself a disservice to the quality of thinking that you bring to legal problems. Because I do see business people learning the law, learning the rules, learning how to adapt those rules, and then arguing persuasively. I'm not sure if it's captured And it may not exist. It may be what we're looking for here doesn't exist and we're not that bloody special. But I don't think so. Otherwise, because Sarah, as a non-lawyer, wouldn't think there's something special. I think it may take a layperson to look at a lawyer and say, that's thinking like a lawyer. So we do. We need to have friends who aren't lawyers. First, that's one.
So who was first? Okay, can you... Does that work?
It's a long time since I've needed a microphone. And indeed, a long, long time ago, where I faced this question. Fully, so I don't need it, Chris. Fully 30, 40 years ago, when I joined the Association of Law Teachers, a debate was then current, and some of you here will remember it, as to whether we were an association of teachers who teach law or an association of law teachers. And it occurs to me to ask Becky, after a brilliant Christmas tree performance, whether there's a difference between thinking like a lawyer and thinking like a law teacher.
Yeah. Is that what you said? Yeah. I was concerned about that, and I thought I'm doing thinking like a law teacher, thinking like a law academic. So I went to find some friendly practitioners and tried this out. Now, they agreed everything that they do is what I said they do, and I cannot, and I'm not telling you they were, I cannot hand on heart say there wasn't a sense of self-flattery involved with some of that. Because I think I may have asked it wrong in terms of, do you think critically? Do you think in this way? So then, separately, and the follow-up questions, so what would you have said if a friend came to you with this problem? My friend Sarah came to me with this problem. And quite honestly, what I saw was, and what questions they asked me back, was going back to the source information and dissecting confidently legal rules, including with one of the questions I asked, went and got a statute book, and they were able to go across the statute book, referring to sections and subsections, cross-referring to with confidence to different acts of Parliament in a way, and it's not that they could read legislation, which, let's face it, is a challenge, but they could do so thinking laterally across the different provisions and then the case law in order to formulate a particular legal answer or answers to particular legal problems. And there's something within that skill set that, yes, you need to know statutory interpretation, yes, you need to understand case law, but it's when it comes together and within the context of a confident command in that set of rules which are peculiar and bloody difficult to learn, that's when you start to see the thinking processes involved. So I don't think it is thinking like a law teacher, although it's rather a nice way to think. It may be thick, but I still got a problem with the word lawyer. And the students say to me, are you a lawyer? Yes, I am. Well, your sister or a barrister? Neither. Well, you're not a lawyer, really? Do you want to have that argument? They never have. I don't know why, it's my face go. Really? But it's all, I mean, you can go to Susskind and all the other things about what is a lawyer. It's something that I wanted to do and got scared of, so we didn't. But I think that may be the crux of the problem in the phrase itself. Thinking like, well, that's why I started with which one? Which lawyer? Or lawyers? Sorry, I'm Carl. Yes, I should.
Thank you, Carl Stitchin from City Law School, and thank you for, I mean, it was really a thought-provoking, fabulous talk. And I think you touched on just now one of the points I wanted to make, which is maybe the best people to answer the question are, for example, for those of us who've been in relationships with people who aren't lawyers, what thinking like a lawyer is, because they may well be able to tell us what it is, both the positive and the negative. For me, the word that also comes to mind, which I think is something we do either implicitly or explicitly teach our students, is about being brave. to be courageous with law. I think of a time when I was in my partner was in a hospital. He had a tube in his nose. It was painful. It was not put in correct, and no one was listening to him. And he was saying to me, "I can't bear this." And I'm thinking, I have to be brave. And that's all the skills and knowledge that suddenly come back, flooding back. I go up to the desk and say, "He withdraws his consent."
Yes.
And someone says back there, "Is he a lawyer?" Or about me. And I thought, well, yeah, it is having that bravery to do what is right with what you've been given through the law.
I agree with you completely. I think the opportunity doesn't often arise in teaching to give students the opportunity to show their courage. It's one of the reasons I love mooting so much. We did mooting as a core assessment in criminal law, and I had a group of 20 students, and every week someone would do a formative moot linked to the seminar question. And I had absolutely delightful student. We were about 6 weeks in, and she was always well prepared. She always laughed at my jokes, so she was clearly highly intelligent. And it was her turn. And she felt like I did before this lecture, but she looked at me, and I said, "You okay?" She said, "I'm terrified." I said, "What?" I said, "Pretend to be me." She said, "Really?" I said, "Yeah. Just pretend to be me." And she stormed it. And I thought, well, I can't. I don't fabulous. And then I said to her, what you need to do with your courage is you need to put it on like a coat. And when you're going out there and you're hitting at it and you're using your law, you may need, metaphorically, to dress yourself in the law and go and fight the good fight. And she's a criminal law barrister. Now, she'd probably be let's not go down the legal aid and the funding and all of that lot. But I agree with you. I think it takes courage to use it as the power of law, the responsibility of law, the moral courage involved with the ethical considerations. Isn't it a complex picture? I remember I've never retweeted more often. I was in a really bad mood. And it was post-letter, and everyone was giving me simple solutions to a really complex problem. And I said, broccoli is a single ingredient food. Legal education isn't bloody broccoli. I've never been retweeted so often. Please don't start the broccoli thing. It's too seeds. And that's what made me start to realise the complexity in all of this and how difficult it is to teach law and how difficult it is to learn. But yes, I agree. I think bravery is a key part to it.
Yes. Kim Silver. Yes, I just think as well, we teach our students, actually we can only teach them a tiny proportion of what is out there. I've been a law reporter in my time and seen it just flash across my desk coming every single day. There is a vast amount there. And of course they will specialise, but actually in their lifetimes, think, what law has developed in your lifetimes and what will develop again in theirs that we can't predict yet. So part of thinking like a lawyer, and somebody said that to me when I was a second-year undergraduate, by the end of this year we'll have taught you to think like a lawyer, and if you want to go and do another subject for a year, feel free, is actually, and that was always proved right, that ability to take another bit of law and look at it and do that analysis and actually work out what it's all about. So
Couldn't agree with you more. I remember the hours I spent learning hearsay and evidence before the Criminal Justice Act, 2003. Completely changed my life. And I remember not resenting the amount of detail I was required to learn as an undergraduate. Not while I was an undergraduate, I was not a very good undergraduate, I wasn't very well. But if I had been, I might have. But looking at the syllabus of some of the places I've taught and thinking, why is it so crammed? William Twining spoke about it at Cardiff. I spoke about it when I did What's the Queue For? Just stop. It's going to change anyway. But what I'd rather have is a student who will say, I will pick up, I've never done family law, and I can pick up a statute on family law and some case law on family law, and I, with confidence, can read it, I can absorb it, I can interpret it, I can dissect it, I can apply it to a particular circumstance, and I can go off. Really, really good students might do it with tax. I've never crossed that threshold. Then you can do it, and that's what I'd rather have. Students who are open-minded to seek out the uncertainty, seek out the unknown, and feel competent to do so. Oh yeah, red pen, we teach too much law. And there's so much more of it all the time.
And to me, that is thinking like the law.
Yeah.
Agla Dagilita, I want to thank you for raising the question and brought me back to my undergraduate degree back in Lithuania, where I did my degree. And that was one of the first lectures. Then we were told that after 4 years of our degree, which is 4 years normally, we will be thinking like lawyers. So that was one thing. And the other thing about role models. And looking now, reflecting on when I was doing my law degree and what I'm teaching my students now, I think there's much more choice. I don't know if it's a time issue or it's a country issue, legal system issue, but the variety of lawyers that they see here, it's much bigger. They see academic young lawyers, they see academic lawyers in sparkly clothes, who will go there completely different, and then there's the other issue of being a female lawyer, and again, my impression was, you have to be strict and you have to wear suits, and that's how a female lawyer looks like. But I think it's good that in our law schools we have different types of lawyers. Some come from legal profession, some from academic background, some come from completely different country, and that challenges, again, opens minds of students that there's no one type of lawyer, and that's the reality.
Thank you, I agree with you. And the understanding that the law can be different, the culture can be different, is something that I know freaked me out when I found out they had different laws in France. How dare they? And we'll try to learn that as well.
Becky, an excellent presentation. Thank you very much. Pat Layton. I have a small suggestion following to speed up the road to Damascus or the Epiphany, which is that every single law teacher in this country should teach law to non-lawyers. Everything that Carl said, what you said about your friend Sarah, says we need to have the ability to stand outside ourselves, which means stand outside our understanding of the law. The part of teaching I've always enjoyed and done most of, I very rarely ever taught law students. I didn't actually quite like them very much, actually, but that's another story. But what you have to do when you're teaching, my first nightmare was teaching a whole class of police officers, and then trading standards officers. And what, of course, you have to do is to tell them why they're there. You have to tell them to teach effectively that they're not learning rules, they're learning what you're talking about, which is a particular process. And that process is of assistance to them, not just lawyers. Because in order to understand law, you have to get under its skin and I think anticipate the problems, the barriers, you called it obstacles, and things that prevent people really understanding. But the role of law in problem solving, the role and law of creating societal rights, etc., etc. So it depends what kind of students you're talking about. But I do think if we all learnt to confront a group of people who are sceptical about what we're doing. I taught a class years ago of very radical health visitors. Was that a contradiction in terms? I don't know. And they just stood and jeered. They stood up and said, "What the hell are you here for? We don't want to hear about this bloody law. It's all about bourgeois people crushing the working classes." And boy, did I learn from that experience. Because you have to go in and explain why, what law is there for, what you can gain from it, and what, in essence, what you're saying, the ability to think like a lawyer. That's my suggestion.
Thank you. My scariest class was trade union activists learning employment
development law in the 1990s. I kept the same, it wasn't my fault. It's not my fault. Don't be cross with me. You've made that.
Can I do a question? A lot of what you were talking about, Becky, was about a journey. And I just wonder, and it may be too big a question, but I just want to put it into the mix, how on earth we manage to explore the consequences of a journey without looking at the journey itself. And I'm conscious here with Julie present. It's one of the issues that I think we do need to be thinking about very seriously, because if we're trying to draw conclusions about the journey by looking at outcome measures alone, I think we're facing enormous difficulties. And you may have a view on that if there's time.
There's a tension. It's a tension I felt keenly throughout the law subject benchmark, and I'm sure that Julie and the SRO has been feeling exactly the same. That on the one hand you need outcomes because they are an objective and measurable way to say competence or pass or threshold. And whether we call it, have you met the assessment criteria, have you produced the thing against which we grade you? I remember Jane Ching and I were mentoring a colleague at Trent. She was mentoring and I was eavesdropping, talking about outcomes, because to get fellowship at the Higher Education Academy, you have to meet certain outcomes against the UK Professional Standards Framework. And this became a huge discussion about how you evidence you meet, the word evidence to lawyers, how you evidence you meet outcomes, and why outcomes are damaging to education because it's more about the journey. And I said, I don't see it as being either or. I think you need to think very, very carefully about the way you describe your outcome. And if the outcome captures that level of that journey to, and I do think that's why the level of it needs to be specified, then doesn't mean you stop. It means you have a qualification of competence at that stage. It doesn't mean because we've got a UK standards, UK education qualification framework, that it means you will go from GCSE fail to doctor. But we've got that framework that does show the journey, and it shows equivalence horizontally, and it shows the journey vertically. And I think if we get this right, people won't want to stop. And it's clear we don't want to stop learning. And I've just had a text from an ex-student who's a barrister who stays in touch. He's still very young. He's in his late 20s. And he regularly contacts me about what else he's learned. He still says that appearing in court is always far easier than appearing in front of me in the root. And he's much more comfortable in the court of appeal than he is. But he's still going through that learning journey. And he still will look for precedents across the common law world that he'll look with confidence and understanding. I don't think they're mutually exclusive, but do I think they're easy? Goodness no. And do you need to think very, very carefully about an outcome that captures a process? Yes, you do. Otherwise it is meaningless.
Can I just pick up on that? I think it's a very helpful and interesting question. Sorry. Thank you. Judy Brannan from the SRA. Very helpful and interesting question. And I think Becky got it spot on, actually, that the important thing is to get the outcomes right. And from us as a regulator, specifying the outcome and not necessarily specifying the journey doesn't mean to say that the journey is not important. On the contrary, what I would suggest is it recognises that the journey is absolutely critical, but that every person will have a different journey. And actually trying to specify particular journeys and put everybody into the same little pots and get them going on the same lines doesn't do justice to your lovely picture that had a person go, the journey going all the way over like that. And everybody will have their own different wiggly line, which is absolutely fine, and we need to recognise the richness of that, and we need, I think, perhaps to move away from thinking that everybody's got to be on the same sort of tram lines, and being clear about what the end point is doesn't mean that you don't recognise the wonderful richness of the journey, to people's different journeys to get to that end point.
Can I finish? But I promised my dad I'd do this. My dad is very, very unfairly on holiday in Antigua, and would otherwise have been here. Yeah, right. And he said, so your presentation is about thinking like a lawyer, and at the end you're going to drink like a lawyer. And I said, I think I should.
Thank you to Professor Rebecca Huxley-Binns. So now we're going to be formal, you see, for that typically awesome talk. I'd also like to take this opportunity to thank City Law School for hosting us this evening and their fantastic hospitality, particularly to Nigel for organising rooms and making tonight happen. Yet again, it's much appreciated. It happens every year, but there's a tendency then to forget that actually the work does go into this. So thank you again, Nigel. And once again, thank you. I think she deserves another round of applause. Thank you to Becky. There is some wine, as you would expect at an ALT event, upstairs, and some light refreshments for anyone who's not an ALT member and doesn't understand the alcohol concept, and some food and nibbles as well. So I hope you'll join us upstairs and continue the conversation. Thank you very much.
Oh, I think you do. Where's your bag? Oh, yeah. Hi, you well? Yeah. What? Come doing? Thank you. Lots of have you made a sense of it for the last 2 weeks? We revalidated the LLD.
I did that, Jim.